Good evening. This is jury member Rebecca Florick, and this is court case number 3. The public hospital corrects impermissible disclosure of PHI in response to a subpoena. The covered entity is General Hospital. The issue is the impermissible uses and disclosures. The plaintiff is Jennifer, and the defendant is AU Hospital. The case follows. AU Hospital, a public hospital, in response to a subpoena not accompanied by a court order, impermissibly disclosed the protected health information, or PHI, of one of its patients, Jennifer. Contrary to the privacy rule protections for information sought for administrative or judicial proceedings, the hospital failed to determine that reasonable efforts had been made to ensure that the individuals whose PHI was being sought received notice of the request and/or failed to receive satisfactory assurance that the party seeking the information made a reasonable effort to secure a qualified protective order. First, I would like to discuss both the plaintiff's side of the case and the defendant's side of the case. Jennifer, the plaintiff, was seen at AU Hospital for medical treatment. AU Hospital then received a subpoena for her records. AU Hospital disclosed Jennifer's protected health information, or PHI, without making reasonable efforts to contact her. The hospital violated the privacy rule by failing to notify Jennifer that PHI was requested for administrative or judicial proceedings without a court order. AU Hospital, the defendant, received a subpoena that did not include a court order. They willingly gave the requester the PHI. And according to the privacy rule, they were within reason to do so. HIPAA regulates that there are 11 reasons why information can be released. However, there are a few stipulations regarding the disclosure of PHI under the privacy rule. The hospital was responsible for making a good faith attempt at contacting the plaintiff and failed to receive a qualified protective order from the requester. The qualified protective order would have ensured that the PHI being disclosed for any purpose other than the legal proceedings or the information that was requested for. The qualified protective order would have required that the information either be destroyed or returned when the legal actions were finished. In response to the plaintiff's statement, Jennifer, neither a court order or an administrative tribunal were presented in accompaniment with the subpoena to the hospital by the requester. With that being said, a subpoena can still be used without them if the proper notification policies of the privacy rule are met. In response to the defendant's statements, while HIPAA grants the release of PHI for specific situations, required by law or not, we do not know the circumstances surrounding the request. With the information that has been presented to us in this case, setting aside dislocation and the patient's right to be notified, under the current perception of the case, the hospital made no attempt to contact the plaintiff about her PHI being released to a third party. Instead, they willingly released her information on the grounds that they had justification to do so without informing the member whose PHI would be released. After reviewing both the plaintiff's arguments and the defendant's arguments, I have chosen to vote in favor of the plaintiff. The plaintiff's PHI was distributed without her knowledge. She was not given the opportunity to object to the release of this information or to approve it, for that matter. without knowing to what purpose her information was disclosed. This is a clear violation of her rights to privacy under the privacy rule. The plaintiff clearly feels as though her rights were taken away from her and had to find out through a third party that her PHI was released without her knowledge. Violations of the Health Insurance Portability and Accountability Act, or HIPAA, can cost more than just a fine. While unintentional civil penalties can be as low as $100 per violation, criminal penalties can cost $50,000 at the low end, with the addition of imprisonment for 1 year. Higher-end violations can cost up to $1.5 million and imprisonment for up to 10 years for civil and criminal penalties. 1 in 8 patients will engage in privacy-protective behaviors due to the mistrust of the medical community and the hospitals who could potentially violate their rights. These protective behaviors encourage patients to provide inaccurate information or even avoid medical treatment altogether. A lack of honest participation in the medical process can have substantial risks to a patient's health and to the treatment plan, while simultaneously harming the medical care system. In regards to harming the medical care system, if a hospital were to do surveys or any kind of other technological or research information that would be based on these patients' medical files, they would be inaccurate. I think that the hospital violated HIPAA and should face either civil or criminal penalties for willfully disclosing the plaintiff Jennifer's information without her knowledge.